Good afternoon, everyone. Thank you for joining us. I think I'll just get kicked off just now. Welcome. This is our latest employment law webinar from Burness Paull on the topic today of the Supreme Court decision, which was announced just last week in relation to Uber drivers. So you're all very welcome. The topic, as you know, is about employment status, and the finding of the Supreme Court, which rocked the headlines, was that Uber drivers are workers under the relevant law and not self-employed, as Uber had argued all along. And it's a long history, this case. I remember doing a blog piece on it even back in 2016 when it was at the entry-level employment tribunal finding in London Central. Even then, there was such interest in the Uber case that we were all interested in following and writing about the topic. So it's been a huge case to follow and a long-standing dispute over this employment status for 5 years. I think, again, it shows the fascination for us in the HR and employment law community to see how our field and our area of interest is played out in the national media. This was all over the news, was it not, in the headlines of the print media and on TV as a top story as well. So I think for today, there's an element of light relief in a sense in that it's about a news interest story, what it means for Uber, which obviously is the key thing. But of course, we're also going to unpack this decision and assess its implications for all employers, for those of you, whether you are in the gig economy or whether you are someone who employs other atypical workers, freelancers and contractors. So what we'll cover today, we'll do a quick reminder of what the law says on employment status, the categories. We'll talk about what the court decision said and what it means overall for Uber drivers. We'll then touch on what it means for others in the gig economy. So those of you that do engage in this platform-based gig economy, as it's called, what does it mean for you? Finally, we'll look at what it means for other employers, if you like, regular employers in the law of the land, so to speak. What's changed, if anything, and what's next? Given the numbers involved, I think we have over 80 signed up today. We'll keep you on mute if that's okay. And you've got the chat function for those. I'm sure many of you are a dab hand with these sessions on WebEx. There's a chat function box that you can click on, and feel free to put some questions or comments as we go along, and Morag and I can take them as we go or at the end. We're not here to give specific legal advice, as you'd imagine. This is more generic analysis, and we'll do our best to cover any generic issues that are raised. But if you do have any particular queries or questions, you can always follow up with us or your usual Burness Paull employment law contact at the end. We will be recording this session, so this will be circulated to you to share with colleagues or to watch back later. That will follow early next week. And we are billed to go on till 1:30, so an hour or so, but it may well be, given we're only covering the one case, it might be we finish up early. So without further ado, I should have introduced myself as I'm David Morgan, a partner in the team here at Burness Paull, and I'm pleased to be joined by Morag, who's my partner also in the employment team. And I'll hand to you maybe, Morag, to kick us off, to start on reminding us, if you could, what's this all about in terms of the law of employment status? What does it matter, and what did it mean?
Thanks, David, and hi everybody. Lovely to have you with us today on a especially sunny day, and we've not had too many of those recently. So special thanks to you for joining when the weather's so nice outside. So yeah, so I thought it'd just be helpful just to kind of cover off a reminder, and I'm sure you're all familiar with it, but just to kind of set the scene, if you like, for the Uber decision, which David will talk about the specifics of in a moment. Just a quick reminder of what the kind of three categories are in relation to status when it comes to people who work for you. And I kind of like to think of it as akin to, you know, your options for going on holiday. You've got your kind of self-catering model, your half board, and your full board. I have to say that's where the analogy stops. There's no all-inclusive option here, and I have to. Holidays are forbidden fruit, unfortunately, at the moment, but hopefully things will look a bit brighter before too long on that front. So there are really, there are three categories of status: self-employed, or the self-catering option, if you like, worker, half board, or employee, the full board option. So just a quick run through those, and a comment on the kind of position in terms of where we were up until Uber. From a legal perspective. So start with self-employed. So self-employed people are contractors who are in business in their own account. Employment law doesn't extend to them because they're their own boss effectively. But do still remember that they have protection in respect of health and safety, and do in some cases have protection against discrimination. But their responsibilities are set out by the terms of the contract that they've got with their particular client. So next up, worker status, and it is that with which the Uber case was concerned. There's a statutory definition of worker set out in the Employment Rights Act, section 230, subsection 3, for the employment law geeks out there. And that provides that a person is a worker if they've entered into a contract of employment, and we're all very familiar with what that looks like, or any other contract, whether it's written or not, whereby an individual undertakes to perform work personally for someone else, and that someone else is not a client or a customer of a business that's carried on by the particular individual. So it's really that second strand that the Supreme Court in Uber was concerned with. So where were we before Uber? Well, the leading case on worker status has been AutoCleanse in Belcher. So that case concerned valleys. And there the court held that the Employment Tribunal was really entitled to look behind the contractual documents setting out the terms for the particular relationship with the car valleys. Now, no doubt drafted by some well-able lawyer, the written terms stated that AutoCleanse was under no obligation to provide work. You'll be familiar with the language that tends to be used. The claimants in that case were under no obligation to accept it. They could provide a substitute. But the court wasn't satisfied with that, and instead held that what really mattered was the reality of the arrangements in practice. And in doing so, when it looked closely at those, it found that the claimants were in fact expected to be available for work, expected to be offered work, and were required to perform the work personally, and with that had worker status. So the written terms there were only one factor to be taken into account. So what does that mean then if someone's got worker status? Well, they're entitled to some basic but quite important employment rights, and we'll come back to those when I talk about what the Uber decision means in practice for the drivers who brought the claim. So they're entitled to get the national minimum wage, they're protected from unlawful deductions from wages, they are entitled to holiday pay, to rest breaks and the other rights afforded by the working time regulations. They are protected against unlawful discrimination, protected against detriment for whistleblowing, and they've got the right not to be less favourably treated if they work part-time. They've also got entitlement to the kind of statutory forms of payment for leave, so statutory sick pay, statutory maternity pay, paternity pay, adoption pay, shared parental pay, and such like. Agency workers are a specific kind of subcategory, if you like, of workers, and they have specific additional rights under the agency worker regulations and associated regulations, which apply from the first day of work. So when we talk about, we use the term workers, we also hear the term, the terms used in practice commonly, casuals or 0 hour staff or freelance staff. So not necessarily the word workers being used, but those are become synonymous with what, from an employment law perspective, means worker. So that's worker status. Last, but by no means least, we've got employee status, your full kind of full board option, and that brings it with it additional employment rights. Most notably, the right to minimum notice if employment is terminating, protection against unfair dismissal, the right to request flexible working, time off for emergencies, and also very topical at the moment, unfortunately, the right to statutory redundancy pay. So There were just a couple of points kind of worth kind of flagging, and they're sometimes forgotten about in practice, but one important point to note is that for tax purposes, there are only two categories of status: self-employed and employed. So the employed status for tax purposes covers both employees and workers for employment law purposes, with both of those categories being subject to PAYE. And we saw that kind of being borne out in practice. For those of you who were concerned with furlough leave at the start of last year, there was a wee bit of confusion when the guidance was first published. Well, let's face it, there was a lot of confusion when the guidance was first published about how furlough leave worked. But the guidance was, it was derived and referred to employees. But actually, one of the questions we got at the time was, what's the meaning of employee from HMRC purposes? And actually, it's that much broader meaning. It includes those who would have worker status for employment law purposes. It's estimated that in the UK, I think there are around 5 million self-employed people at the moment, those are that's possibly the number who report and pay to HMRC, and over 30 million employees. So that's the number of people who are subject to PAYE in the UK are estimated to be so. So coming back then to the kind of Uber decision and this question of status, so that you're thinking, well, that's all very well and good, I kind of understand that, Morag, but the real question is deciding the particular status that an individual has in practice. And unfortunately, that's never been an easy question to answer. The cases about employment and worker status go back many, many years. And I would say it's probably remained pretty much impossible to set down a clear set of defining criteria, again, definitively a particular individual's status. And for that reason, been more, particularly in recent times, for the of different models of working, many of which have developed. So that's a brief introduction to status. So David, do you want to tell us a wee bit?
Thank you, Mark. You were breaking up a little bit at the end, but I think that's over to me now. Thank you, Morag. So yeah, against that background of the legal structure, we'll talk about Uber. So what does it actually mean? What does it tell us? What was it all about? And it's very fact specific. By their nature, these cases are very fact specific. So it's about applying the facts to the law to get the right outcome. And it's a challenging area, probably one of the most difficult areas, as Morag said, of employment law practice. So here we go. Let's look back to the history. There were two lead claimants, the names you've probably seen in the news, Mr. Farah and Mr. Aslam, and they had argued that they were workers and that Uber was their employer, but it was worker status only that they went for. So to be clear, right from the start, they never tried for the full board, if you like. They never tried for the gold standard employee status. They were going for that middle bracket of worker status. That's what they always claimed in the tribunal. There were 25 claimants in total, and the two headline grabbers were Farah and Aslam. Uber from the start, right at the beginning at the tribunals, they disagreed. They argued, and what they tried to argue, and it is for those that use Uber, for those like myself that rely on the platform, fascinating reading actually, and seeing the genesis and the chronology of how Uber approached it. They said, no, wait a minute, we're just a tech platform. We're a technology platform. We provide a service to our drivers. We connect drivers with passengers. We're just their agent. We're not in the business of transportation services. That's what Uber said. We don't have cars and we don't have fleets of drivers. Nothing to do with us. We're just a tech platform. And based on that, they said the drivers are independent contractors. So they're the self-catering. They're the self-employed people. They're not workers. They lost at Employment Tribunal and Employment Appeal Tribunal at the beginning, both of which held that in reality, these drivers were workers. And importantly, as it then played out later when we come to the Supreme Court, in the early stage, what the early courts held at tribunal level was that these guys were workers. The drivers were workers when they had the app switched on. So if you can visualize in the drivers, they've got the app on screen. When they click that on, they become workers effectively at that time. And when they're in the territory, say London was the key focus, that's when they're working. And the language was pretty powerful that many of the judges used right the way through the Uber journey. And one quote I loved from the early stage was that the judge said, "The notion that Uber in London is a mosaic of 30,000 small businesses linked by a common platform is to our minds faintly ridiculous." So very powerful challenges to the whole structure, the whole business model of Uber when they lost at that stage. So Uber take it to the Court of Appeal. They lost there as well. And the focus of the Court of Appeal's judgment, which was very interesting again, was about the relationship. So look at the true relationship between driver and Uber, very like AutoCleanse that Morag mentioned, which was again the Supreme Court that held. You take into account all the circumstances in the relationship, how you interview the drivers, how Uber fixed the fares. They had a performance management approach. So looking at all of these things, the Court of Appeal also said in quite scathing terms, again, the quote they used that always stuck with us as the bloggers at the time was the high degree of fiction in the wording of Uber's contractual documents. And that then becomes a theme when we look at the challenges that the Supreme Court gave to Uber. So it's moving away from any emphasis really on the contractual wording. And let's be honest, that's what we do, isn't it? That's what we as lawyers do in supporting you as employers. Oftentimes, the first thing we're asked to do in dealing with casuals, freelancers is fix the contract, would you? Make the contract as robust as you can to make sure that these guys are not employees or are not workers. So that's the bit that came under a lot of criticism, both at Court of Appeal and then to Supreme Court. So there we go, off to the Supreme Court, which came out last week. And it was a unanimous decision dismissing Uber's final appeal. It's the final word on it then. This is a binding precedent now as it relates to Uber. They upheld the findings of the Employment Tribunal. At the Supreme Court, of course, Uber maintained its position. It said these guys are independent contractors, they're not workers. So what the court had to do was really apply the legal test that Morag outlined at the outset, interpret what the meaning of worker is. And I think where maybe there's anything new, and given it's so fact specific, what can we learn from it? We'll touch on that later. But the key shift, I think, in the judgment was that the Supreme Court opened quite cleverly, I think, by saying, look, let's not get bogged down in the contract here. This case is not about contractual rights. It's not about what the contract says. And let's be clear, they were pretty frank about this, written by teams of lawyers, armies of lawyers. They've been described in the press, armies of lawyers from California to the UK, all around the world working for Uber to try and get these perfect contracts. But it's not about contractual rights. The rights that Aslam and Farrer were seeking, as Morag said, national minimum wage, working time, sick pay, these are creatures of statute, creatures of legislation, and that should be the focus. So what the Supreme Court said is, let's go back to the law, and what the tribunal has to do is focus on statutory interpretation, not contractual interpretation. That's the start. And furthermore, what the judges said unanimously were that the court should give effect to the purpose of the legislation. And I thought that was quite eye-opening, or quite maybe a light bulb moment as well. Go back to first principles. What is the point of having this law in the first place? The right to minimum holidays, the right to minimum wage. And what the Supreme Court said is the purpose of that law is to protect the vulnerable, protect vulnerable individuals who have little or no say over their pay and their working conditions. Why is that? Because look at the bargaining power. A driver versus a multinational conglomerate in Uber. They are subordinate to them. They are dependent. So these are words that we've seen in a lot of the case law over many years, but that subordinate and dependent relationship of driver to Uber. Take it back to that purpose. There's small wonder then, of course, that the judge and the court said, well, actually, these people actually are workers and they're not truly self-employed people. So they held that the purpose of the legislation is to protect the workers. That should be the starting point. Because otherwise, if the court and the tribunal at first instance had allowed Uber effectively to manipulate or to craft the contract in such a way that would be, as they put it, it would reinstate the mischief which the legislation was designed to prevent in the first place. So if lucrative employers with expensive lawyers can craft these contracts in such a way to contract out effectively of the law, that wouldn't be fair. And in fact, it's unlawful. The legislation cannot be contracted out, and we know that national minimum wage applies to all of you who employ and engage people, workers. So that wouldn't be right to be able to just put that in writing to contract out of it. So they said that applying the worker test, the tribunal was justified in finding that the drivers were workers for Uber. And then looking at the facts, and this is what makes it quite a fact-specific case for Uber, visualize the experience as a passenger. There's 5 key aspects that the Supreme Court focused on. The first is that Uber sets the fare. So when a ride is booked and you on your app as a passenger, it's Uber that sets that fare, not the driver. The driver cannot charge any more for that. So Uber dictates the pay for the work done, as you might expect as an employer to a worker. The contract terms are imposed by Uber. So when you do it, again, it's not like for those of you in the real world, so to speak, engaging with a worker, an employee, here's your contract of employment. Do you have any comments? Senior employees will mark up a draft and send it back to you. The contract terms are imposed by Uber for use of the app. The app comes up, they have to click accept. They don't have the opportunity to negotiate it. The bargaining power is completely skewed in favor of Uber. Thirdly, once the driver has the app logged on, their choice of acceptance of rides is heavily constrained. So there's an acceptance and cancellation policies and penalties for drivers if they keep declining rides, for example. They can be locked out of the app. So that feeling of control and subordination over the workers then came on to the next point, significant control. There's a rating system, as you know. You can rate your driver, that feeds into the app, and there's algorithms that then impact upon the drivers as a result of that. And finally, the 5th point, the driver has no control over interaction with customers. In fact, Uber takes steps to prevent their drivers from having relationships with customers. It's all about Uber rather than the individual driver. Like a self-employed chauffeur, for example, having personal relationships, that doesn't work in the platform that Uber offers. So ultimately what the court held, applying all of that, this key piece on insubordination and dependency was central to their decision. Effectively, there was no scope for the drivers, as the court held, to improve their economic position through their entrepreneurial skill. They're basically an Uber driver, and that's that. So for us, when we go on the app, we're not looking for a particular driver. We get who we're given effectively when we click here for a driver in Uber in your area. So workers was what the court held. The next bit that's maybe of less significance in the normal world of work, if you like, is about working time, which is a huge point, because I think where they developed it was that the claimant's working time, the Supreme Court held, was not limited to the period where they drove passengers, but it included the time when they were logged on and ready and willing to accept assignments. So as you imagine, that's a lot longer in time, and how that dilutes the working time and the impact on national minimum wage. So that's probably where the big numbers might well be, maybe of less interest, I suppose, for freelancers and casuals, but certainly from Uber, I'm sure that really had many tails wagging at their end. So in conclusion, Morag, I think the key thing for me on the judgment and what the Supreme Court said was about giving a backseat to the documentation. And I have to say, that's quite a shift. We used to often advise clients, well, first things first, what does the contract say? Now, AutoCleanse and other cases have told us for many years, the contract isn't definitive. You look behind the contract. You look at the purpose, you look at the practical reality. But I think that maybe the shift for me with the Uber decision was it's moving away from the contract altogether. That's almost a back seat now. And the front seat, if you will, take the Uber analogy, is the reality of the relationship. So front and center is the reality of the relationship and the purpose of the law that is there to protect the individual. So what does that mean then, Morag? We've got the judgment, we've seen all the rhetoric and the panic, if you like, for Uber. What does it actually mean, would you say, for Uber drivers past and present?
Yeah, well, I think, it's funny because there's decision, but actually the one question that is where does that leave the drivers? What difference will that make to them? And potentially it's a significant one from a financial perspective. There's no further right of appeal. It's final. The game is so first and foremost, some 5 years later, and David will maybe later in terms of the kind of lack of effective enforcement mechanism for people in the driver's positions. Yes, they can bring a claim, but look how long it takes to get through the system. So some 5 years later, it means that the drivers are entitled to claim national minimum wage or for breach of contract. That means that they could claim up to 2 years back pay. You'll know, of course, that what you can claim as by way of unlawful deduction of wages was limited after the change in approach to holiday pay calculations. There is some doubt as to whether that's a lawful approach, the limitation of it to 2 years, or if they bring their claim as a breach of contract claim, they could get up to £25,000 in the Employment Tribunal. Through the civil courts, they're not as restricted in terms of what potentially they could get back. They could claim up to 6 years back pay in the county courts in England, and up to 5 years in the sheriff courts in Scotland. Separate consideration is also that national minimum wage can be separately enforced by HMRC. They can take a range of enforcement measures. They can serve notices of underpayment, civil penalties, do naming and shaming, and we've seen quite a bit of that recently. And they can recover underpayments through the civil courts, and worst case scenario can lead to criminal prosecution. So you've got to think that HMRC will come under pressure to take more action on the back of the Uber judgment. So that's national minimum wage. The Uber workers can also claim 5.6 weeks paid annual leave each year. Now, interestingly, and for those that follow holiday pay developments and leave developments, there's no specific remedy set out in the working time regulation for a situation where an employer allows a worker to take leave, but only on the basis that it's unpaid. And as a result, the worker chooses not to take their full leave entitlement. But the Uber driver's claim, in my view, will not be dissimilar to that of Mr. King in the Sash Windows case, which might ring a bell with you. That was a case where there's a reference to the European Court of Justice made by the Court of Appeal. And the ECJ's decision was that a worker hasn't exercised their right to paid holiday over years and years and years because they know that they'll not get paid for it, and their employer has wrongly and unlawfully failed to provide holiday pay, then the Working Time Directive from the ECJ's perspective requires that that worker be allowed to carry over their paid holiday rights year after year until termination of employment. So, potentially that's another significant liability from Uber's perspective. I'm just checking, can you hear me all right? Yeah, David, can you? Yeah, all good, okay, yeah, fine. As far as entitlement to any form of statutory leave pay, so things like statutory sick pay, maternity pay, paternity, claims for non-payment of those can be raised through HMRC. Now, again, there's been very little talk of this in the press, but the drivers may also have claims for auto-enrolment pension contributions that should have been made on account of worker status for auto-enrolment purposes. Now, claims for those can't be brought in the Employment Tribunal. The means for enforcement of those is through a complaint to the pensions regulator and a request for enforcement action to be taken, which can include compliance and, again, penalty notices being issued. So if you start to add that up, you can imagine that the financial implications for Uber may be significant, not least in respect of back payments owed, but also in terms of future payments that may be due. Now, the solicitors acting for the claimants say that the ruling, in their view, could be applied to the tens and tens, I think it's estimated about 60,000 drivers although it's probably more than that now, who've been active with Uber since 2016. But the Uber decision itself was brought by 25 drivers only, and as I say, as David said, with two kind of lead claimants. If other Uber drivers who were not one of the 25 want to bring or to assert their worker status, they would need to now bring claims or complaints on their own behalves. Uber, it's fair to say, on the other hand, seems to be downplaying the significance of the judgment, and perhaps not surprisingly, saying, we respect the court's decision, but that focused on a very small number of drivers who used the Uber app back in 2016. Since then, we've made significant changes to our business, guided by drivers every step of the way, including giving them more control over how they are, providing new protections like free insurance, providing sick pay and other such entitlements. That, I have to say, does contrast with their own business statement. So when Uber listed its shares in the States in 2019, its filing with the US Securities and Exchange Commission included a section on risks to its business. And there it said that if it had to classify drivers as workers, it would incur significant additional expenses in compensating the drivers for things such as national minimum wage, overtime, and went on to say that actually any such reclassification would require them to fundamentally change their business model and have an adverse effect on their business and their financial condition. So does that mean it will tweak the platform so that it reduces control, allowing the drivers to be genuinely self-employed? If it does so, that will mean the booking app itself will be less able to guarantee a uniform service. The alternative would mean raising prices for customers to cover the additional costs associated with worker status. Or will it accelerate their plans to bring in self-drive cars and eliminate what they may see as the headache and the cost of human labour? Either way, I think it's fair to say that the company's business model in the UK will have to change compared to that which was applied in respect of the drivers who brought the claim. That's from Uber's and the driver's perspective. David, what do you think about the judgment from the point of view of other kind of gig economy operators?
Thanks, Morag. Yeah, and I think it will be fundamental, because now the changes that we're going to have to see are going to be, like you said, for Uber about the business model. I think that's going to be the impact now. But first off, I suppose I'd open by saying, despite any headlines or otherwise about, oh my goodness, the impact of this case on the gig economy, as we sit, doesn't do anything really, doesn't change anything to other gig economy operators, platform operators, other delivery drivers, etc. It doesn't change that. It's not a precedent in that sense, and it immediately affects people because it's fact specific and it relates to Uber, and it relates to Uber people at that snapshot in 2016. These cases are so fact specific, so they're painful in a way. So if you're a gig economy worker and you want to piggyback on the Supreme Court's judgment of Uber, you're going to have to start at the beginning. You're going to have to put a tribunal case in and work a way through and think, actually, how am I going to fund that if my employer takes me all the way to the Supreme Court with deeper pockets like Uber did? So any future cases, guys, will still always be on their own facts, and we watch all of them. And in a way, is this not just more, let's be quite frank, time and money for lawyers to be fighting these cases? Deliveroo is a case I've been following since its inception, and it comes up to the Court of Appeal shortly as well. So Deliveroo, we all know that. When we look at actually the streets of urban environments in the UK now, it's these guys that are out in the streets. It's Uber drivers, it's Deliveroo riders. The Deliveroo riders came together to try and form a trade union of their own, a specialist trade union for the gig economy, and they set up an independent trade union to do so. They approached Deliveroo to get recognition. That was rejected, and they therefore went for compulsory recognition to the Central Arbitration Committee. The CAC, in an unusual shift from the norm of these cases, held that Deliveroo riders are not workers, so they lost. That was quite a shift from the norm. the test is quite similar, a little bit different, but similar test for the word worker. So CAC said no, and the key thing that the Deliveroo guys lost on was the right of substitution, and that's often been held to be quite a major change. So, you know, for those that employ employees, you can't expect someone just to send their mate to do their job the next day. That right of substitution is pretty fundamental. Deliveroo drivers on paper have the right to send their friend, to send someone else to do their work for them. In practice, as I understand it, that's very rare. But anyway, it was that bit that influenced the CAC, went to the High Court, Deliveroo won at the High Court. So that's now being appealed to the Court of Appeal. And now that the Court of Appeal is sitting and has got the Uber judgment with that emphasis on purpose and on statutory interpretation, I think a lot of commentators, myself included, would be surprised actually if Deliveroo were still successful at the Court of Appeal. But there's an example to answer your question, Morag. We've got other gig economy operators closely looking at this. So the focus is now going to be practical reality, control, and subordination. So I think it's going to move from what I mentioned before about get your lawyer to draft the contract, quick change the contract in light of Uber. I don't think that's how we're going to be able to do it now. I think in future, what gig economy operators will have to do is take Uber, unpick it, and completely change their business model. So, you know, build in less control, if that makes sense. Try and shift, you know, actually give the right of substitution. So try and completely change that. If they do that, then they lose that flexibility that often both sides want. If they don't do it, then they're going to be stuck with sick pay, holiday pay, and minimum wage. So that's going to raise costs. So maybe the business model has to change in other ways. So as I say, I think for me, that's the key thing, the key implication for other gig economy operators watching this. It's not going to change overnight. And they could actually now, I think in reality, anyone reading the high profile nature of Uber, they could get a wave of other claims. And actually, maybe the next wave will be employment status. Because as we said, Uber was only but worker status, not the gold standard. But when you read the judgment, it doesn't sound that different from employee status,
Yeah,
you know?
yeah.
So maybe that'll be a bunch of Uber people saying, you know what, actually, I think I'm an employee. I want my notice. I want to claim unfair dismissal when I get bumped off the app by an algorithm. So I'm afraid that this is still going to continue. We're going to have another wave of claims in the gig economy.
Yeah, and I mean, I
But
think, you know, I mean, and not just confined to the gig economy, you know, important, absolutely. But I think probably the case is just as important for any employer. You know, it's not just about the gig economy. The case really ultimately is about anyone who's in a position of subordination where the employer has written terms which purport to classify the worker one way or another, and the extent to which you look not at those, but then actually at what's kind of happening in practice. And you know, people working in those sorts of conditions aren't restricted to the gig economy. We've always had them. You know, nearly all the decided cases on status aren't about gig workers. They're about people, you know, from across the labour market, lap dancers, golf caddies, labourers, taxi drivers, and beyond, who've been labelled as self-employed, regardless of whether, you know, they worked for an app or not. So I think the case is also, you know, a really salutary reminder for all employers of the importance of assessing true status of individuals who you've labelled and treated as being self-employed from an employment law perspective, but whose true legal status might be that of worker, or as you say, David, even employee. And not just doing it once, keeping that under review, and then ensuring that the intent and the correct legal status is properly reflected in the day-to-day dealings with that person. So as you say, you know, the test is now focused very much on not what the contract says, but the degree of control that's exercised on a day-to-day basis, with the contractual piece only one factor to be considered. So, you know, looking at those that you engage and you treat as self-employed, would they fall within the worker test as set out in Uber, or indeed the employee test? And it's not an easy undertaking. It's a bit of a black art, and you know, assessing status involves, you know, a wholesale assessment of all of the features of each of the different types of working relationship which you operate. And then what do you do when you identify a risk? Well, you then need to decide how you're going to handle that without raising awareness of potential back pay claims for the likes of holiday pay, national minimum wage, and so on. I guess it's not dissimilar to the holiday pay dilemma faced by employers when the law and calculation of holiday pay changed. Do you do nothing and kind of hope that nobody notices? Or do you change approach, say by agreeing to give worker or employee status and benefits associated with that going forward, but then risk alerting people to past issues that you've not correctly categorised them and to potential kind of back pay claims, and how then do you deal with those? So these are not easy decisions, and there's no one size fits all approach. And of course, an added consideration for private sector employers on the horizon will be the new off-payroll working regime in respect of self-employed people who contract to personal service companies. So watch out for webinars on that in the coming months. Never a dull moment in employment law. So David, what next then, do you think?
Yeah, I mean, looking at the kind of not political statements and what have you in the back of the court judgment, but I suppose as an employment law geek, as we both are, Morag, what does the judgment say? It's not an indictment of UK employment law, is it? UK employment law
Working, I
won
would
here.
say. Yeah.
It worked.
Yeah.
The law was interpreted by the biggest legal brains in the country. The indictment probably was the enforcement or lack of enforcement of those workers' rights, because it took 5 years for these drivers, test case drivers, to get justice. And they were punching the air, of course, outside the Supreme Court. Will anything change for them? As we said, it remains to be seen. Will it change for their tens of thousands of peers? Who knows? But where do we go from here for the worker who's trying to get justice, and then for us in the main acting for employers? How do we advise our clients? That's the most uncertain and unacceptable thing I feel in my career. It is a really complicated area of legal practice. It takes the Supreme Court to tell us just for one organization. So it's an unacceptable position, I think, for you that have dialed into this webinar to be in. When you have taken on a freelance or a casual worker, you deserve an answer, I think, from your lawyers to say, are they employees, are they workers, or are they truly self-employed? An exercise we did for a media business actually a number of years ago, and we applied our own tech platform. We put together a workbook which answered 150 questions about their freelance population. And the HR director said, once and for all, I'm going to get to the bottom of this. They employed 3,000 freelancers, and they populated answers to questions at a weighted score underneath the Excel workbook on whether they wore the uniform, whether they had the email address, whether they had a security pass, how many days they worked, how long they'd been engaged. All of these things were given a score based upon the case law analysis that we had made. And we used the lap dance case that Morag referred to. We used auto cleanse to kind of give the workings behind the scenes. And what HR said is, we will do what that workbook comes out at. So if someone comes out as self-employed, we're going to keep them at that, but we'll put them on a limited company. If someone comes out as an employee, they've been here for a number of years, we'll give them a contract of employment. As Morag said, for those that went to limited companies, along came IR35 to confuse things as well. But it is still, I think, an unacceptable position that we cannot advise yourselves as our clients on what the position is. So the political bit maybe is taking it back to government, taking it back to the legislation. How do we regulate the labour market in the UK? Should there be agencies that deal with this and not courts? But most importantly, if you recall, it wasn't that long ago, but actually when I look at the date 2017, it's quite some time. The Taylor Review, remember? The Taylor Review was commissioned to look at the new ways of working, to look at the gig economy, to look at flexible working, to look at the evil of the 0 hours contract. And on the back of the Taylor Review, it came up with recommendations that became the Good Work Plan. Remember that? A number of recommendations in the Good Work Plan about greater flexibility. They were very aspirational. Both the review, the Taylor Review and the Good Work Plan were very aspirational. And one of the evils that they said, there should be detailed tests for employment status set out in legislation. It should focus on control. So all the things that maybe the Supreme Court have looked at, but we're still no further forward. So Brexit came along, of course, diverting everyone's attention. Then came the pandemic, so I'm sure it's way down the list of priorities for the government as well. Will Uber maybe lobby? I understand they did that in California, and California did legislate in their favor, actually, to give a status for workers versus employees. There's been some commentary after Uber, which is maybe the law of unintended consequence might be you remove worker status altogether and just have employee or not employee. I think the truth actually, Morag, is it's who's going to draft this. I wouldn't fancy having the job of writing an employment statute or statutory instrument to define what most employment lawyers have struggled with since the 60s. And you still have the Supreme Court wrestling with it and coming up with a beautifully written judgment. So how do we write that into law? But I wrote a piece for the Law Society Journal on this a number of years ago saying that's the answer. I was criticized by the editor, came back to me and said, well, how would you write that, David? So I tried to come up with something, but control, subordination, look at the statute, but it would be very difficult to write. But I think that's where the tide has to turn, that we take this out of the hands of the courts, having to determine on such a lengthy and piecemeal basis, and instead we have a written law that tells us once and for all what the status of worker, employee, and self-employed truly is.
And I think one of the suggestions the Good Work Plan had was some kind of online status determination. I guess not dissimilar to that's been used for the off-payroll working regime already for public sector employers, and it will come into force for private sector employers. So I guess there's a starting point there for those of you who are familiar with the kind of CESS test for HMRC purposes, but yeah, pity the poor person who has to kind of develop that from employment law purposes.
Excellent, Morag. So I think we'll wrap up maybe at that stage. Lisa had asked a question about going over the 5 key points the court looked at. We'll follow up with that if we could, Lisa. And again, it will be on the recording to go back over those key points there. Tom's made a very good point as well at the end about the issue of tax and NI going back. Absolutely, you could just imagine that would be another thread, wouldn't it, for the drivers to take this to HMRC and challenge if they go for employment status, if actually there's been unpaid NI and employee taxes. That could be another crippling issue for business models like Uber, so it will not be lost on them as well. So unless there's any final questions, that's maybe as good a point as any to wrap up and to thank everyone for joining us today.